like to welcome Professor Jonathan Turley, who is the Shapiro Chair for Public Interest Law at George Washington University Law School. Professor Turley is a nationally recognized legal scholar who has published work in areas ranging from constitutional law to legal theory. Next, we have Ms. Eileen O'Connor, who is a former Assistant Attorney General at the United States Department of Justice Tax Division. As former Assistant Attorney General for DOJ Tax for 6 years, Ms. O'Connor supervised DOJ litigation of civil, criminal, trial, and appellate tax cases. Next, we have Mr. Bruce Dubinsky, who is the founder of Dubinsky Consulting, a forensic accountant. Mr. Dubinsky has accumulated over 40 years of financial, investigative, and dispute consulting experience, served as an expert witness over 100 times, and has testified in over 80 trials, including trials involving criminal and civil financial fraud. Lastly, we have Professor Michael Gearhart, who serves as the Burton Craig Distinguished Professor at the University of North Carolina, Chapel Hill. Professor Gearhart has been a law professor for more than 30 years. He's the author of 7 books and has written more than 100 law review articles and dozens of op-eds in the nation's leading news publication. Pursuant to Committee Rule 9G, the witnesses will please stand and raise the right hand. Do you all solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? Let the record show that the witnesses all answered in the affirmative. Thank you all. You may be seated. We appreciate you all being here today and look forward to your testimony. Let me remind the witnesses we have read your written statements and they will appear in full in the hearing record. Please limit your oral statements to 5 minutes. As a reminder, please press the button on the microphone in front of you so that it is on and the members can hear you. When you begin to speak, the light in front of you will turn green. After 4 minutes, the light will turn yellow. When the red light comes on, your 5 minutes is expired, and we would ask that you please wrap up your testimony. I now recognize Professor Turley to begin his opening statement.
Thank you, Chairman Comer, Ranking Member Raskin, members of the committee. It's an honor to appear before you today and to talk about what is undoubtedly the most weighty constitutional decision that you have under Article 1, other than the declaration of war, and that is the potential impeachment of a President of the United States. It was roughly 25 years ago that I appeared in the impeachment proceedings with other experts in the impeachment of President William Clinton. It was 4 years ago that I appeared in the impeachment proceedings for President Donald Trump. And then it was just 3 years ago that another impeachment occurred without any hearings at all. The shortening intervals between impeachments should be a cause of concern and circumspection for all the members on both sides. And I want to emphasize what it is that we're here today for. This is a question of an impeachment inquiry. It is not a vote on articles of impeachment. In fact, I do not believe that the current evidence would support articles of impeachment. That is something that an inquiry has to establish. But I also do believe that the House has passed the threshold for an impeachment inquiry into the conduct of President Biden. Having said that, I want to just address 3 inescapable facts that led me to that conclusion. First, President Biden has indeed spoken falsely about these foreign deals. The Washington Post and other newspapers have noted that some of his past comments are demonstrably untrue. Second, President Biden was the focus of a multi-million-dollar influence peddling scheme. And then finally, President Biden may have benefited from millions of dollars as a part of that scheme. Now, those facts should not be taken out of context. They're merely allegations, and they should not become presumptions of impeachable conduct. Indeed, as I've said in past impeachments, self-dealing is a difficult issue under the impeachment clause. The framers sought to avoid ambiguous standards. That's one of the reasons that perfidy was rejected. While it may not sit well with many, President Biden and other presidents can be dishonest, can even lie to the American people, and that would not constitute an impeachable offense. Indeed, most presidents have lied to the American people. That's why I've not liked any president since James Madison. Now, dishonesty alone is not impeachable, and so what I lay out in my testimony are what I call guardrails or best practices. Those are designed to protect this process. Frankly, a number of the things I lay out benefit President Biden, as I say in my testimony. Because presidential impeachment shouldn't be a closed question, it shouldn't be a rush to judgment, and you should avoid the type of confirmation bias that can occur in this process. This is, as people say, a political process, but it is also a constitutional process. Influence peddling is a form of corruption. The United States has signed treaties to combat this form of corruption around the world. And that is also an inescapable fact. We need to find answers as to some of these questions. I'm running out of time, so I'd like to make one last observation, if I may. These are constitutional moments that demand the best from each of us to transcend the politics and passions of our time. It calls for something that's difficult. It calls for solemnity and clarity for members. We have become a nation addicted to rage, and we can fuel that. This body is a powerful teacher, as Brandeis said, and you can teach that, or you can teach a respect for this process. It begins here and now. We can disagree with each other without hating each other. These are important issues, and I think they're close issues. And I think some of these issues really do gravitate in favor of the president. So I would simply say that this is a moment where members and citizens can stand together without prejudging the evidence. And I thank you for the honor of appearing before you today.
Thank you, Professor Turley. Ms. O'Connor.
Mr. Chairman, Ranking Member, members of the committee, the chairman invited me to share my thoughts on the conduct of the tax investigation into Hunter Biden. I make my comments on my own behalf as a private citizen and not on behalf of any person with whom or group with which I might be or have been affiliated. When I learned that experienced IRS special agents had felt compelled to report to Congress about the obstruction of their criminal tax investigation, I felt compelled, too, to share my understanding of how things are supposed to work with people who have no reason to appreciate how disturbing the whistleblower's allegations are. Without context and a frame of reference, it's difficult to know sometimes how seriously to take things. In an October 2022 meeting of the Hunter Biden prosecution team, U.S. Attorney Weiss admitted it was not his decision whether to bring charges the investigation had proven should be brought. This directly contradicted Attorney General Garland's sworn testimony 6 months earlier. This was the final straw. After more than 3 years of having his investigation stymied, but nonetheless having proven substantial criminal charges, Supervisory Special Agent Shapley realized he had to come forward. In fact, he had come forward before, internally within the IRS, using the procedures developed for that purpose. He had complained up his chain of command as early as June 2020 about the obstruction he was encountering, but there had been no response. Once Shapley had taken steps to come forward to Congress, Special Agent Joseph Ziegler did the same. It was not the whistleblower's testimony, however, but what followed that compelled me to write. My first Wall Street Journal article was called "Throw Hunter Biden's Plea Deal in the Trash." Given the substance of the whistleblower's testimony, the plea deal Weiss had worked out with Biden was a miscarriage of justice. After that commentary was published, I heard from many people who were similarly appalled at the unfolding injustice. Many were knowledgeable and experienced tax professionals. Perhaps the most commonly commented on aspect of the handling of the Hunter Biden matter was that Weiss had permitted the statute of limitations to expire on prosecuting provable offenses. This was appalling. It is not significant that the plea agreement, it is not insignificant that the plea agreement was announced on June 20. Let's review what came just before. On August 19, it became known that IRS employees were going to let Congress know about the obstruction they were encountering. Later, Shapley and Ziegler sat for hours of sworn and subscribed testimony with the House Ways and Means Committee staff. It was expected that the committee would make the testimony public. It did, on June 22. U.S. Attorney Weiss, with his June 20 announcement of a plea deal, beat the publication of the whistleblower's testimony by the skin of his teeth. 2 days. If the whistleblowers had not come forward, would Weiss have brought any charges at all? My second Wall Street Journal commentary was published on July 25. It was called "You'd Go to Prison for What Biden Did." Given what Shapley and Ziegler testified they had proven, and the charges the tax division reportedly had authorized, the plea deal represented serious injustice, not only to law enforcement, but also to people who have been caught up in this system and have suffered the consequences the law provides. I received a great deal of positive feedback on this commentary, too. People understand that for laws to be respected, they must be enforced. The nature of any investigation is the following of leads. That didn't happen here. This team was not permitted to search the guest house of Joe Biden's Delaware mansion and Hunter Biden's storage facility in Virginia, to interview family members and business associates, to examine Hunter Biden's abandoned laptop. By November 2019, the FBI had confirmed the devices were Hunter's and the contents were authentic. But the Hunter Biden investigation must not be viewed in isolation, rather as part of a broad landscape of corruption. Don't forget that a full year after that, in October 2020, FBI officials were telling Twitter that the laptop was Russian disinformation. The whistleblowers tell us that the tax investigation of Hunter Biden was an offshoot of an investigation already underway into an online pornography platform. That is how investigations develop. Agents follow wherever the leads take them. And when they take them in the direction of a new investigation, they open one. Question: if U.S. Attorney Weiss had been in charge of that pornography investigation, would he have blocked the investigation into Hunter Biden's tax crimes? I thank the committee.
Thank you, Ms. O'Connor. Mr. Dubinsky.
Good morning, Chairman Comer, Ranking Member Raskin, distinguished members of this committee, guests, and my fellow citizens. Thank you for this opportunity to testify today. First, at the outset, let me state unequivocally and in no uncertain terms that I agree to testify today not because I have a political agenda or axe to grind, because I do not. Rather, I agreed to testify in this proceeding in order to help this committee and the American people gain a better understanding of how frauds are committed, how complex business arrangements, sometimes using limited liability companies, sometimes those being shell companies, are used in frauds, and how money is moved by fraudsters to facilitate the conduct of illicit activity. Let me be clear, I am not prejudging the facts that have emerged to date with regard to the Biden family and associates businesses and the money they received that had its origins from foreign sources. I am not here today to even suggest that there was corruption, fraud, or any wrongdoing. In my opinion, more information needs to be gathered and assessed before I would make such an assessment. I'm here today to lend my expertise to answer questions that this committee may have while they advance this investigation and gather more facts about the business dealings surrounding the Biden family and associates businesses. Throughout my 40-year career as a certified public accountant, a forensic accountant, and a certified fraud examiner, I've worked tirelessly to uncover the truth when it comes to cases involving allegations of fraud, corruption, and wrongdoing. I've investigated some of the world's largest frauds, including have investigated and testified in the criminal case for the United States Department of Justice on the Bernie Madoff Ponzi, the world's largest Ponzi. I've worked on cases like the Enron case, the International Brotherhood of Teamsters election corruption cases, as well as some of the United States' largest cases of tax fraud, to name a few. As the age-old proverb goes, where there's smoke, there's fire. As a fraud investigator, when I see smoke, I immediately look for the fire. The critical question facing the American people today is whether behind the smokescreen clouding the Biden family and associates businesses, was there or is there a fire? And if there was or is a fire, how big is that fire? Why were members of the Biden family and close business associates receiving millions of dollars of payments from foreign entities and individuals? What services, if any, were being provided? What was the substance of the alleged services being provided? Was the money being paid for a fair amount commensurate with those services? Were political favors being traded and disguised as services? These are the questions that, as a forensic accountant, I routinely am asked to answer when I'm hired to investigate allegations of corruption and fraud. There's a great deal of evidence that has been collected to date by this committee and others trying to answer these very questions. However, much more information is still needed in order to be able to answer these questions and make a final determination as to whether or not the Biden family and its associates' businesses were involved in any improper or illicit activities, and importantly, whether those activities, if any, were connected to President Joe Biden or then Vice President Biden. In my experience, fraudsters purposely create a labyrinth of limited liability companies to create an opaque network of entities that are then used to hide improper conduct. In many instances, These complex business arrangements are typically centered around illicit activities and involve moving money around the globe in a manner designed to avoid the detection of the underlying illegal activity, as well as the movement of the money tied to that illegal activity. Gone are the days, for the most part, when suitcases full of currency or gold bars are exchanged as payment in the conduct of illegal activities. Today, more sophisticated methods are employed to obfuscate the true nature of such illegal activities and to hide the movement of money. The importance of following the trail of money is a critical component of any fraud investigation. The term shell company has its origins in the world of business and finance. The term shell, as you would note, implies that the company is like an empty shell, lacking substance or real activity. Shell companies typically have no employees, no offices, no real operating businesses. They use P.O. boxes for mailing addresses. While I will note shell companies can be used for legitimate business activities, more often than not, they're associated with fraudulent activities like tax evasion, money laundering, hiding of assets, and other illicit practices. It takes a heavy lift to pull the covers back on these shell companies to determine who the true beneficial owners are, where the money went, and to expose the true sham nature of their existence. However, through the use of legal subpoenas and proper investigative methods and a great deal of persistence, fraud investigations can and do expose the identity of the wizards behind these curtains and the extent of their illicit activities. In closing, let me underscore the importance of conducting a thorough, independent, and unbiased investigation of the matter before us today before you reach any conclusions. The American people deserve to know the truth. The rigor and discipline of a well-planned and executed investigation should not be subverted by political motivations or aspirations. To do so would critically undermine the integrity of any such investigation and any conclusions reached. Thank you again for this opportunity to be here today, and I look forward to answering your questions.
Thank you very much. Professor Gerhardt.
Thank you, Mr. Chairman. I want to thank the ranking member as well and distinguished members of this committee. I appreciate the honor and the privilege to be able to appear before you today to talk about the basis for an impeachment inquiry of President Biden. I think a good place to begin is with the Federalist Papers. And in the Federalist Papers, Alexander Hamilton warned of the dangers of trivializing impeachment through petty partisanship. He foresaw that impeachment may, and now I quote, agitate the passions of the whole community and to divide it into parties more or less friendly or inimical to the accused. In many cases, it will connect itself with pre-existing factions and will enlist all their animosities, partialities, influence, and interest on one side or on the other. And in such cases, there will always be the greatest danger that the decision will be regulated more by the relative strength of the parties than by demonstrations of innocence or guilt. I think Alexander Hamilton knew what he was talking about, and I think what he said may well describe the current set of proceedings. One thing I might add to all of that is that the framers designed an impeachment process to follow or comply with several safeguards. And it's important that we keep these safeguards in mind as these proceedings go on. The first is the necessity for credible evidence of the commission of treason, bribery, and other high crimes and misdemeanors. There is not, at least not that I've yet heard, such credible evidence. Let me give you an example of what I fear is similar to the current proceedings. Hunter Biden is arrested for speeding in a car owned by his father, and the police go after the father. I don't think that's how the law should work. I don't think that's how impeachment should work. I respect members of this committee enormously. Believe me, I'm just a law professor and citizen, and I come here with great awe when I speak to an important body like this. But I listened to Congressman Jordan, whom I respect a great deal, when he said there are 4 facts. Hunter Biden was on the board of Burisma. Hunter Biden was not qualified. So far, by the way, nothing about President Biden. Third, there were executives who asked Hunter Biden for help. Again, not yet any proof about any kind of complicity of President Biden. And lastly, Joe Biden gave a speech. If that's what exists as a basis for this inquiry, it is not sufficient. I say that with all respect. And I think that that is part of the problem I think, and many Americans think, may exist with respect to these proceedings. A second safeguard is the Fifth Amendment Due Process Clause. It requires fundamental fairness. And I think in these proceedings, something has happened to President Biden that was said to have happened to President Trump in 2019. And that is the burden has flipped to President Biden to prove his innocence. Any further investigation is being done to ensure that Mr. Biden has to prove his innocence rather than the committee being able to connect the dots in a convincing and persuasive way. It's not me you have to persuade. It's the American people whose trust you deserve and whose trust you have to maintain. A third principle is judicial review. And here I would just remind the committee about the Supreme Court's decision in Trump versus Mazars. The court said about this committee that, in fact, it has to conduct an investigation for a legitimate purpose. A fishing expedition is not a legitimate purpose. Moreover, the court in Trump versus Mazars said that it is not a legitimate purpose for the House or House committee to be conducting the function of law enforcement. And I heard many references here to criminal misbehavior, to whether or not somebody should be thrown in jail, criticisms of a prosecutor, Mr. Weiss. That sounds to me like an attempt to really substitute for the proper legitimate proceedings of the House. Two other safeguards real quickly. One is that these proceedings should be based on principle, not partisanship. And I fear that what we're hearing today, which can be traced all the way back to 2019, and accusations made against Mr. Biden as far back as then, are really driven by partisan animus more than they are by principle. And a final safeguard is for the House, the full House, to authorize an impeachment inquiry. That does not come from me. That comes from Speaker McCarthy. He said there should be the full House's approval. It also comes from Mr. Trump's Justice Department, who said there must be a committee must be authorized by the full House. That has not happened here. My concern is with the Constitution. That's what my devotion is to. And I hope all of us understand that there's nothing more serious than honoring our Constitution and following the design the framers gave us.